advanced directives. Advanced directives are those, we're talking about things like healthcare powers, living wills, all of that. That's dealing with the person. Okay. And again, everybody's familiar. I'm assuming that everybody's familiar with this stuff, right? Okay. So, and you all have an advanced medical directive appointing a healthcare representative, correct?
Yes.
I see too many yes, okay? Okay. So what you're doing is you're appointing somebody to act for you, and I'm going to get into a little more depth in this. And then, how many of you have heard of MOLST? Just a few. Well, we'll talk about that a little bit. Okay? DNR? Okay. And there is way too much informal healthcare decision making. We'll touch on that. We try and see that all our folks don't have to rely on it. So here's what the statute says. Any person over the age of 18, which brings me back to something. At what age are you the only person that has the right to make decisions about your health care? What medicines you take, what surgeries you have, what hospitals you go to. At what age? 18. Unless you're an emancipated minor, you're married, there's some exceptions to this, okay? But basically 18 for the vast, vast majority. So, at what age should everybody have named a healthcare representative? 18. 18. Here a few years ago, I was interviewed several times both on TV and radio about these kind of topics, and most of the interviewers ask about, when should you start doing this stuff? I tell them 18, and they look at me like I got two heads. This is not understood by people out there. There's been many a mother who is incredibly frustrated because it happens when kids go off to college. Can you find out what's going on with them? Well, there's a lot you don't want to find out, trust me. Okay? But in fact, well, there's a woman that worked for me for a number of years. Her son was going to school up in Vermont someplace. And he called Mom every day. He had Asperger's, very bright, but some social issues. But he called Mom every day, and then one day he didn't call. Well, she didn't think anything about it. And he called the next day. She thought about it. End of the day, she called him. He doesn't answer his phone. And after about 4 days, she still hasn't heard from him or managed to talk to him. And what's Mom doing? She is freaking out. She somehow found the phone for his room. He was living in the dorm. His roommate answered the phone, and she wanted to know if he'd seen her son. And he says, "Well, I'm not real sure. It's been a while since I've seen him. I think last time I saw him, he was going to the infirmary." Now what's Mom doing? She's totally freaked. She calls the infirmary, and she wants to know, has my son been there? What did they tell her? We can't tell you anything. So she's taking time off from work. She's getting ready to drive to Vermont. And he calls. He met somebody. He was busy. He didn't have time to call Mom. How long do you think it took her to get him to name her as his healthcare representative? Okay? He came home for a weekend early. Okay? So, but a lot of times it's way more serious than that. Okay? So, can execute a document addressing directions for medical treatment, including withholding or withdrawal of medical treatment. It must be signed, dated with at least 2 witnesses. Again, what's a camel?
A horse.
Horse designed by the legislature. Designed by the legislature. Okay? There is a new sound system in my future. Okay? So, what we see all too many people have, what they have is they have a document that they wrote some names in and they got it signed. And hopefully they got it executed properly with witnesses. But in fact, the law says, you know, this can act, you can have the right to express what your wishes are. You are not obligated to use the camel the legislature created. It may or may not be fine for you. We find that a lot of people want something when they know they can do something different that's a little more comprehensive. Okay? I talked about the sample forms. I'm giving you the statute there. And the legislature, to make it simple, they have a statutory form that includes a living will plus the healthcare power of attorney form in one document. Okay? They also say, well, you can do them separately. And if you'll read the document carefully, the living will, I don't believe, makes it clear who is supposed to be making that decision. Okay? And we think that that decision should be spelled out very clearly, that it is who I've named as a healthcare representative. And I believe it's probably colored by the fact that my first wife started 3 different palliative care programs in 3 different hospitals during her career. And the thing that what the biggest problem she had with doctors was they would not prescribe enough pain medications with end-stage disease processes. Drove her crazy. And so we have gone to some lengths to try and build in the fact that the most important thing is keep me comfortable. And we vested the power clearly in the agent under the healthcare power. Because it's about, see, I don't believe that anybody wants any document. They want a result when they need it. And they want it to be the result they want, just not something. And the better job we do of being explicit about what we want, and educate the clients about what's possible, the better results we're going to get, the results that are more closely suit them. Okay? Now, the statute is really clear. You do not have to use the statutory forms. They're furnished to give you a guideline of what might be. Okay? For most of our clients, we don't use statutory forms. So, how many healthcare representatives can you have?
More than one.
I heard more than one from some brave souls. I'm going to get you talking to me before the day's out. It's going to happen. Yeah?
2.
2. How about 3? Maybe 4? Now, I want you, now, you all deal with families, right? So let's say we've got a family with 4 kids. And so we name 2 of them as healthcare representatives. Could there be a problem there? Well, back up in the work you do, because you deal with families. Do the kids always agree?
No.
No. In fact, they rarely agree, right? So while you can name multiple agents, I rarely see folks wanting to name more than 2, but and forgive me ladies, but I have a lot of mothers, they've got 2 kids, they want to name both of them, they got 3, they want to name all 3 of them, they got 4, they want, okay? Because you don't want anybody to feel left out, right? Okay. But here's the problem, you're the doctor. You're the doctor. And you have 2 people who are named here as healthcare representatives. And one's one says cut and the other one says no. So what, you just cut a little bit? Well, what do you do? You can't do anything. So I personally don't favor the committee approach to making what can be really critical decisions. Any of you participate in committee meetings? How long does it take to get stuff done in your committee meetings? Forever. The doc in intensive care wants to know whether he should, cut them open or not, doesn't have forever. And so if you, and you know in advance whether or not two people are going to agree about something. It's not possible. So we try and work with the client to try and figure out who they should name first. If that person is not available, then we make it clear that, here's number 2. And sometimes we'll go number 3 and number 4. And I believe that we get much better results from that. Okay. Living will. This is probably the most significant part of the planning that we do for clients. Because literally this is about life and death. This is not about fixing something, that's about being here or not being here. Okay? The living will doesn't come into being in terms of affecting the outcome until the doctors have determined that not only are you terminal, but your death is imminent, or you're in a persistent vegetative state. Now, think Terry Schiavo, right? Any of you remember Terry Schiavo? Now, here's some things that I'll tell you about Terry Schiavo. If she had had just the statutory forms in Florida, named her husband's healthcare agent, had a living will, we wouldn't know about her. I'm positive of that. And in fact, and there's another thing that Terry could have done that I believe would have made a big difference, even if she didn't have the documents. Don't construe that for me saying you shouldn't have this in writing proper, okay? Is what we know is she never talked to her parents about what she wanted. So one of the things I want you to take away from here is if you haven't talked to your adult children, found out what they want and vice versa, that's one of the most important things you can do. Because if you've named somebody, you're asking them to participate in a decision that can end your life. Wouldn't it be nice to give them a little direction about what you want? Okay? Or, if they were really tough teenagers, maybe it's a way of getting even with them. Okay? You've got to talk to them. I'd like to believe that Terry Schiavo's parents would not have litigated this, through all the courts and the legislatures that they did, had she ever talked to them. Whoa. I can't do it. Let's try one. There we go. Healthcare power of attorney. It should be furnished to the attending physician. In fact, it doesn't mean anything until the attending physician has it. The American Hospital Association did a study almost 20 years ago. I don't think it's quite that long. And what they concluded is that 90% of the people who ended up in the hospital and said they had these advanced directives were not able to produce them on a timely basis. Now tell me, if you can't produce the document when it is needed, is it any good? So we came up with a plan after running into this, so we make sure that all of our clients, and we've got a service for it, to make sure that these documents are available when they need them. Okay? So, the next thing, so we got the document there, then the attending physician has to determine that you are incapacitated. And that's basically, you can't process the information the doctor's giving you to be able to make and communicate a decision about that information. So there are a lot of folks who don't do this because they don't want to give up control. So what this statute is telling you is that as long as you can process the information and communicate your decision about it, your agent under a healthcare power of attorney has no authority. And that's frustrated many an adult child, because they think mom should be in the assisted living facility, or should, you know, you go down through the list of stuff that kids think the parent should do that relates to their person. The fact that you've named them doesn't give them any authority until these two things happen. Okay? And the doctor is obligated under the statute to tell your healthcare representative that, hey, I have documented in the medical file the mom can't be making these decisions anymore. Now, of those three things up there, guess which one is followed the least? The third one. Okay? Now, so what we've tried to do is get all of these things on a couple of slides. And in fact, if you would like this, other than the way you have in your handout, if on that gold sheet on the back, if you'll put, you know, HCPOA, Healthcare Power of Attorney slides, make sure we've got your email and we'll send you a copy of this. Okay? Because I think it's helpful to look at all of these. You can see here, who can create it? Anybody 18, emancipated minors, married, or high school graduate, if they have capacity. Same for the living will. And here's where a lot of people get confused. DNRs do not resuscitate. That is a medical order. It is created by a doctor, and it has to become part of your medical file. Attorneys don't do this. You can't do it yourself. It comes about from communication with the doctor. You can see that the first two are signed by you if it's on your behalf. The physician signs a DNR. You can, as long as you have capacity, you can revoke your healthcare power of attorney. The living will. And I had a group of doctors and nurses really cranky with me here last fall, because I was doing a presentation on this stuff for them and capacity and other issues. And who does it say, when can you revoke your living will? When can you revoke your living will? Anytime. You merely have to be able in some manner to communicate that you want to continue to be treated. You do not want that document, that living will, to be enforced. I had two doctors who got up and out of that program after we had some conversation back, and they left. They were so upset about that. Okay? Healthcare power, effective upon incapacity. Living will is end-stage medical conditions only. One of the reasons in our practice is why we don't do the combined document. We've got different standards. And I don't trust that medical professionals are going to read these documents real closely. And I think it is better to separate the healthcare power of attorney away from the living will, because you don't want them revoking the healthcare power or not revoking the living will. Okay? Now, you notice we say binding on medical professionals is healthcare power. It says yes with an asterisk, and you've got something similar for the living will. there are a number. I'm going to try this side for a moment. Okay? See if this works. There are a number of institutions, they're in every state, who will not honor a living will. So even though you have one that is validly drawn, meets all of the legal standards, the law is developed such that that institution can say, we treat everybody for everything forever. We won't not treat, we won't withhold treatment. So one of the inquiries that needs to be made by your healthcare representative is, what is this institution's policy in regards to withdrawal and withholding of life support? We make it clear that our healthcare representative has the ability to move somebody from institution A that won't honor to institution B. Okay. Finding on emergency personnel. What you have to know is if you have EMTs show up at your house or at the park or wherever, they are obligated to do everything they can do to revive you. Period. There was actually a woman who tattooed DNR on her chest. Trust me, it won't work. Okay? What does work is an out-of-hospital DNR order. You can have one for, in-home, and if you've got serious end-stage disease processes going on, you're going to want to get that, because you really don't want the EMT showing up and trying to revive you if that's not what you want.
Where is that sheet?
Well, that's an order you get from your doctor. It's just like the DNR, the same as you would get in a hospital. You talk to your doctor about it, and they will help you complete all the paperwork. They'll complete the paperwork they have to, so you got a valid document. And then ideally, you're going to make sure that you get that. You put it on a refrigerator. You see that the local fire department, wherever the EMTs are for your living circumstances, wherever they are, make sure that you send it to them, and that increases the likelihood it's going to be honored. Okay? Can anybody guarantee you that it's going to be honored?
No.
No. But you got to do the things that can increase the likelihood. Okay? So, end-stage medical condition. You can always make these decisions. The only way you're not making the decisions is if a doctor has determined and made part of your medical record that you can't process the information and communicate your decision. Okay? Now, process, you ever talk about people not having insight? You have clients who don't have insight into their circumstances? Well, this is part of what we're talking about. Just because somebody can continue to carry on a conversation doesn't mean that they actually are processing and understand and can apply that information to their circumstances. Because it's a really tough job we're asking the doctors to do. Okay? And the conservator can do all of those. Everybody can do all of it. But as long as you can, you're the one doing it. That's probably the critical thing to understand. Okay. So we've been talking about one of the big issues is compliance. Okay. Doctors are not as good about following the rules as they should be. And sometimes that's a good thing because we have so many people who haven't done what the law allows them to do. Okay? And we've already talked a little bit about revocation, living will anytime, healthcare power, as long as you're competent. And if a doctor, don't cough, it doesn't like If a doctor hasn't determined that you're incapable and your healthcare agent is then authorized to act, are you capable or not?
I'd say yes.
Right. Because the law says you're presumed to have capacity. So until something happens that we get it documented that you're not capable, at least in this arena, presumption is that you are capable. So you can, in most cases, revoke it. How about countermanding the decision of the agent? The agent has decided we should withdraw medical treatment. Can you countermand that order? Absolutely. The agent says, we definitely have to put you on this drug because it's gonna keep you here. Can you countermand that order? Maybe. If it's merely giving you a pill, they're gonna give you the pill if you are not, if it's been documented you don't have capacity. But the law gets much more complicated. We have to start sticking needles in you. Because you may be able to countermand that even though you have some capacity issues and it's been documented. Okay? So trying to figure out how to deal with all of these different levels of decision making and impact on your life and invasion of your person or whatever, huge challenge. Okay? And there are no perfect answers, unfortunately. Sometimes it's clear, a lot of times it's not going to be. Most. Now, only a few of you, I asked earlier, there wasn't very many of you that heard about most. Can I see those hands again? Okay. So, most is medical orders for life-sustaining treatment. It's got, in other states, there's something called HOLST, physician's orders for life-sustaining treatment. Same creature by different names. And these are going to look different in different states, what they're asking the doctors to do. But basically, is having the doctor talk to you about what your wishes are regarding your health care towards end of life. Okay? Now, it is a form the doctor is to complete. Okay? Now, patients approaching the end stage of life with limiting illness or a condition of advanced progressive frailty. So if you just get old enough, I think I've got a client who's 97. Actually, I got a client who came in on his 100th birthday. He thought he should do some planning finally. Well, does he need to have most solars because he's 100, right? He's outlived children, relatives, all his friends. Okay? Should he have a most completed? Well, probably. But it's not just because of age. There's supposed to be a medical condition that suggests that, because of your physical state of health, that you're nearing, your body's not going to be able to last that much longer. Okay? It's instructions about what other healthcare professionals should know about life-sustaining treatments. Okay? It involves discussions with the signing clinician, the doctor, about this stuff, current medical condition, what's to happen next, your values and goals, possible risks and benefits of treatments that may be offered. Now, anybody been to see the doctor in the last year? Yeah. Now, how long a discussion did you have with the doctor? Did you discuss your personal values and how you think about life? Okay. So, it's got to be signed by the clinician, the patient, or their legally authorized representative. Who might be able to sign this besides the patient?
Healthcare power of attorney.
Could be, yeah. course, it needs to be witnessed. Now, you will see page 15 of your supplementary materials. A couple of things we put in there for you. We've got some frequently asked questions about MOLST that help you understand it a little bit better. And I don't know, I can't really read this form very well, certainly, but this is the form, the next after the frequently asked questions. This is a form the doctor's supposed to take the time to go through and get the answers and have a conversation and complete that form, and that becomes part of your medical file. And with electronic records, medical records is supposed to follow you around. Any of you deal with electronic medical records? Do they work real well? They follow you around real well? I found they get completed pretty well, but I haven't found that they follow that well. Okay? And we're having some conversations with the UConn Jerry Psych group about doing some things on capacity and what have you. In fact, the capacity conversation, would it be interesting or useful if I were to have a geriatric psychiatrist be part of that piece of the presentation? Speak up. Yes? Or no? Yes. Okay. Boy, I got to talk all day. I'm going to make you talk some. Okay? So I'll look into that. But one of the questions I asked him, because the MOLST became part of the law October last year. This is new. Okay? It was after about a 3-year pilot program, trying to see if it would work. And what I asked, this is the head of the department, and I asked him how he thought the docs in the practice were doing. And guess what he told me? They're just not doing it. Okay? Because it's an interesting problem. I do think the conversation and thinking about these questions and talking about it with somebody is really, really important. Okay? For everybody. And maybe before you're frail or you're in stage, think about these things. Okay? Well, here's one. How many of you expect to get out of here alive? I don't mean the room. It's not that bad. Okay? Okay? Okay. Sooner or later, all of us are going to have to deal with our own mortality. And we as Americans do a terrible job of doing that. Okay? So I think beginning to think about this, and especially as you're dealing with older clients and the issues they have, I think one of the things I'm saying, okay, this has got to be done by a doctor, but that doesn't mean the doctor's the only one that can talk to them about it. Because I do think that if you go to the doctor and say, Doc, I'm not doing well, I think we need to do this. I think we need to maybe help people become more proactive. Just a thought. Now, I think I promised, because we're a democracy, kind of, that I would take questions before the break, and we're actually right up to about the break. Yes, Larry?
You're dealing mainly with wills, but if you get a trust, if your client has a trust, that's another whole ballgame, isn't it?
Well, we're going to this morning and this afternoon talk about trust, but no, I haven't talked about wills at all yet. Okay? Yes.
It still costs $200 to process conservatorship with probate? It used to be $200.
Oh, I can't tell you what the fees are. All I do is sign the checks when we file. They've raised almost all of the probate court fees. Yeah, is it $250 now?
Yeah.
Yeah, they just keep inching them up, okay? There's somebody else had her hand back, all the way back there. You.
Yeah, you're talking about giving information to your doctor and what you would like to do. What about if you're traveling, you have an accident in a foreign country, and you find yourself in a hospital? So what happens about these directives?
Well, if you're our client, our process makes sure that information is available. However, for most of the world, it's a zoo. Okay? Sorry, I don't have a better answer, because that is a very real concern.
Take your
So-
directives with you while you're here,
Yes.
so that you can have somebody present them wherever you are.
So I saw some other hands. Yes.
What's the youngest you've ever seen appointed to a healthcare representative?
What's the youngest age that I've
Do 20-year-olds get asked to do that, or 30-years?
oh, it's really the question is at what age
Yeah.
do we see? I occasionally see folks naming adult children who are in their mid-20s. I've never seen an 18-year-old named, and if somebody was going to name an 18-year-old, we would have a conversation about that level of responsibility at somebody that young.
How does the mid-20s do from your perspective? Do they do okay, or would you prefer an older person?
Well, it depends. Because, and I got to, the question is about, how does somebody in their mid-20s deal with this, having to make these kind of decisions? I've not, at this point, had a early 20s who's had to make these kind of decisions, but having seen them have to deal with making financial decisions, most of them don't have the level of maturity that's appropriate to dump that kind of responsibility on them, in my experience. Okay? Yes?
Well, to piggyback on that, I work in the ICU, so we've had situations where there's 18-year-olds, but a lot of times, from my experience, they've had family, like a grandmother or an aunt, for that situation that is very supportive of them. I've had only child who has to make that decision for a single parent that is just unexpected. And you would say it's a young parent too for that age, but they have family that usually supports them so far from my experience. But I have a question. Just going back to the healthcare representative, you didn't specify like a number. You have up to 4? Is that the max?
Oh, okay.
Or
Are you
there's no
talking
max?
named to serve simultaneously or sequentially?
All right, well, explain on both of that then.
Okay. Well, if you work in ICU, right? Okay. So you have 4 children standing in front of you. And the document says that the 4 of them decide. 1 disagrees and 3 agree. What do you do?
It's usually,
No. Answer the question I posed.
that gets difficult.
Oh, no, that's impossible. That's impossible. Because if you follow the direction of the 3, you now have violated the terms of the agreement and you can get sued by the 1. Okay? Now, so we spend, as you might guess, we spend a fair amount of time trying to get our clients to understand this. If they ultimately, after we have walked through here's how it works in real life, okay? And they want to name a committee, whether it's a committee of 2 or, and the bigger the committee, the worse it is.
Yes.
Okay? Then that's what we do. But most clients, when they think through and they put themselves in the position of the healthcare professional having to deal with it, they pretty automatically see, well, if they don't agree, okay, now sometimes mama says they'll all agree. I'm picking on moms because I got mostly a female audience here. But that's usually the one who's driving, we want to name everybody, okay? the mother. If you, it is better, in my opinion, to name who you really are going to look to, because if you talk to people much, you figure out, yeah, there's one I'm most comfortable with,
Yeah.
okay? And then it's the one who I'm almost as comfortable with, and then the one that, well, they do, and if nothing else is left, I'll go to this one, okay?
While everybody else is dead in the car wreck, dead the black sheep.
Yeah, so we tend, most of our clients are tend to name, 2 to 4 people. I've had some who've named more, okay? And the statute lets you can name 147 of them in order if you want. Okay, wouldn't that be a great committee meeting? Okay, and the other thing we encourage them is, and you gotta talk to them about what you want. Because just how you see the world, even though, and it's mostly parents to children, but sometimes it's to siblings and,
Yeah, it's like the next option.
yeah, and whoever it is, you gotta talk to them because they don't know what you think. And if you wanna find that out, actually go talk to them. Okay? And if they do understand how you think, that's great. There's nothing lost. Yes, in the blue back there.
I have 2 questions. The first is, it sounds like, well, it's not a question maybe, that if there's multiple people appointed as healthcare rep or POA, that we really need to look at the document and make sure that it's sequential or all together, correct?
Yes.
The second thing is
And consult an attorney before you decide.
Okay, well, we have an attorney that works, so we can do that.
Yeah.
Because I work in hospice and home care, so that's a huge issue.
Oh, yeah.
When it comes to the end of life. The second is that we've had people who've had conservators who will say, yes, they can go on hospice, but when it comes to the DNR, you have the physician, but then either the patient or the person also signs part of the form. And many of the conservators say that we have to go to court to do the DNR. Is that correct?
Well, that's up to the conservator. Okay, and are you?
They're saying that that's part of
The
the
best practice for these kind of major decisions for a conservator is go to the court and get the court to say, yeah, you're okay.
Yeah.
Okay, that's, because part of that is, that's the only way you can protect yourself. Okay? Okay? So, yes.
What about when there's no documents? And I'm in a house and I have someone who's dying. And this is what I was told, that if there's a spouse, they can make the decision. If there's no spouse, you go to the children and you do eldest down.
Yeah.
Is that?
That's an informal process, but the problem you've got is if you have any of those people who disagree, you're going to end up with a conservatorship. Okay? Because any of them can file a petition for a conservatorship.
But in the meantime,
In the meantime, okay?
I can do that?
You can generally do that.
Okay.
There's a whole lot that gets done because sometimes you got to do something. Okay?
Yeah.
There was somebody else I saw with a question. Did I get up? Oh, is this another question?
Well, I went to another seminar, and when I heard about the children, it's not about who's older, they all have to agree in terms of the end of life piece.
Well, that's the problem. Okay? It's the only way that, see, it is so easy to solve these problems if we can get you people to just do a little bit. Okay? They're just essential things that people need to take care of. Because you both deal with this stuff a lot, and you both have different set of what you believe the rules are. It's really easy to not have that problem to deal with. Okay? But you got to get clients to cooperate in advance before they get there, and they all plan to do that, right?
Right.
Okay? Yes, one more time.
Is the DNR bracelet, the orange bracelet, still a legal document when people are being transported by an EMT?
As far as I know. No. Yes, Larry?
As a social worker working with people, can you declare that this is my opinion, but I'm not an attorney, and, you know, well, and does that relieve you of any responsibility?
Can
Or
you,
can I still sue you?
can you declare them what?
You can declare to the whoever, the people involved in the case, that you are not an attorney, you have no, you don't have that kind of authority. I'll give you my opinion, but it's only my opinion. Is that worth anything?
Well, it's worth as much as your opinion's worth. Well, no, I am not, I know you think I'm being a smart aleck, but no, the fact that you express an opinion, that's all you've done.
Right.
Okay, if somebody chooses to act on your opinion, that mostly is gonna fall on them, but be careful about how you express that opinion.
Okay, good.
Okay?
Okay, good,
Okay?
thanks.
So, in the far corner back there.
If you're in a client's home helping them complete financial directives, is it legal or illegal to have the social worker review it? If you're the only one other person?
Well, a healthcare provider professional should never be the witness. If you're responsible for the healthcare or the payment of it, should never be the witness. Okay? Okay? So, one last question.
If you're presented with a most form areas of it well, they're conflicting, which ones you will provide?
I don't know the answer to that. So, no, because it hadn't been decided. We've got a statute that is 6 months old. Do you think any judge is opined on this? Not yet. And I'm not aware of anything in the statute that addresses this potential for conflict. Okay?